one site, two claims, and centuries old battle over faith and history. Yes, this is another land dispute which questions the history and faith. I am talking about Bhojshala dispute in Dhar district of Madhya Pradesh, where the Muslim side of this district has gone to Supreme Court because the High Court has declared this particular site to be a Saraswati temple. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand that why this dispute is going to a higher court, to the apex court now, what is the background to it, and most importantly, when we are looking to apex court for this decision, what will actually come out, what can expected as a solution. Now we do come from a country where we have such disputes over history and faith because of the years of culture, years of heritage and diversity that comes along with it that has been seen. So when we are talking about the present case, it is such a case where we are seeing that we have Bhojshala complex. It looks something like this from the outside, and as this image clearly shows that we have presence of a temple as well as a mosque. Now what has happened here is that as of now the High Court has declared this to be a Saraswati temple, but the Muslim side has taken this judgment and they have appealed it to the higher court. Now the appeal has been made by the caretaker of the Kamal Maula mosque which is present there. So this is a Bhojshala complex which is known as the Saraswati temple, and it has also a mosque present there. Now when we are looking at the judgment that has already been given by the High Court, the High Court says that this whole complex is a fundamentally just a temple which was dedicated to goddess Saraswati, and the evidence by this High Court which has been seen, they are saying that this was an ancient Sanskrit teaching center, the temple remains up present, and they have also discarded, quashed Archaeological Survey of India's 2003 order, because of which Friday namaz was running. So on this temple, both of the religions were using this complex. On Friday it used to be for namaz, and for Tuesday it used to be for the Hindu prayers, and also most importantly on Vasant Panchami this complex was used by the Hindu community. So in this context, what has High Court done? High Court said that this usage which was allowed as per Archaeological Survey of India 2003 order, that will not continue. What will be done? How will be the administration looked into? That can be decided by ASI and Center, and this is what the High Court ruling looks like as of now. Now the Muslim side was not happy and they have filed a petition in Supreme Court. Now let us look at the history, the layers of identity, the layers of architecture, and who contributed to this whole dispute arising. So we have to start our story from 11th century. This is where you will find the connect of history and the term as well, where the word Bhojshala is coming from. We are talking about 11th century. This particular complex is believed to be built by King Bhoj, who belonged to the Parmara dynasty, and this Dhar district, this region was a major Sanskrit learning center. Now that is why this particular complex housed a famous Saraswati temple. It was temple of Vagdevi, and that means this was seat of Vedic education. That is why where we have evidences of stone inscriptions where walls were inscribed with important literary, academic works, grammar rules, etc. Later comes in the medieval transition. That is 14th century to 15th century, when we are talking about Delhi seeing sultans, Malwa seeing sultans. Parts of this complex were transformed into a mosque which is going by the name Kamal Maula Mosque. And then we come to the modern times, that is the colonial time. The Vagdevi temple, which had the statue of Vagdevi, that was excavated back in 1875 by Britishers, and it was moved to the British Museum in 1902 itself. So a big evidence was taken to the Britishers by them to Britain itself and put in their museum. So as of now, that statue is present in the British Museum itself. Now based on this, there was shared use, and that is what Archaeological Survey of India had arranged, that there will be weekly access to the complex based on certain days to both of the religions, so as to manage the tensions which were present. So Tuesday was for Hindu Puja, Friday was for Namaz, and Vasant Panchami also was for Hindu access. Now, a recent ASI survey was conducted, and this happened in 2024, where ASI went through a comprehensive scientific and archaeological survey, and this was based on High Court order. Now, what did this survey found? This survey found that yes, the temple materials was present, yes, there are statues and sculptures which were found, including one of Lord Ganesha, one of Lord Hanuman, and there were Sanskrit inscriptions as well. So, survey concluded that there were extensive Hindu, Jain iconography, inscription, and there was reuse of temple structure. And that is why, based on that evidence, High Court verdict was given, where court ruled that this complex is fundamentally a Hindu temple, a center of learning. The usage of it by the Muslim community on Fridays should be quashed, and that is why the Muslim side has filed a petition to look into this order by Supreme Court. Now you have to understand, the dispute is also not just rooted in history, but also when the usage, shared usage was continuing to manage that tensions, why that has particularly sided with a given community in this context. Now this clearly shows that the shared usage, reuse, the continuity of prayers of the both communities, and it also gives us a direction that Dhar was one of the cultural Vedic centers of the ancient as well as medieval times. Now this is where we come to the second factor. When we are talking about the High Court ruling, let us try to understand why this judgment is being so much emphasized on. This judgment is being so much emphasized on because this case involves multiple fundamental rights. We have understood what High Court has ruled. This particular case raises multiple religious freedom question, which might be in violation of certain fundamental rights, such as Article 25, which talks about fundamental right for freedom of religion. Article 26, right to manage religious affairs. Article 14, equality before law. Article 49, protection of monuments. So these are fundamental rights, yes. But when we are talking about protection of monuments, Article 49, this talks about the DPSPs that state is responsible for. But where does the role of court limit itself, or where does the limitation will be placed on the religion? These lines are absolutely blurred, and this is one judgment that can be expected from Supreme Court, where the lines will be drawn very clearly, which will give a preview into this more clearly. And that is why this petition to Supreme Court becomes more important, this High Court judgment itself, because this has national aspect involved. Another key important component which makes it an importance of national level is the Places of Worship Act 1991. Now this is the act which states that the religious character of places of worship as of the date on which we got independence, that cannot be changed. And this is intended to prevent any future communal dispute. If we go based on this legislation, then it is an absolute contradiction what has been said by the judgment, because if we looking at August 15, 1947, it was being used by Muslim community as well. If we are trying to change it, the judgment is changing that, then it is in contradiction with legislation. And that is why multiple questions are emerging for this Bhojshala case. That can historical evidence reopen disputes even after the presence of a legislation? How should shared worship sites should be treated? And does Bhojshala actually fall in the protection of this legislation? All of these answers will come when the Supreme Court reviews that petition and answers key questions such as, will the High Court ruling be valid? What purpose does ASI evidence serve? What are the worship rights when we have them as fundamental rights, and what are the scopes and limitation present to that? And can there be share use traditions as well? Because this is something very sensitive. If you look at the broader concerns, not just the answers that Supreme Court will be giving, this is about communal issue. This is very sensitive, this is something fragile, and this will require security deployment in this region, and this will bring answers to the constitutional questions. What are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.